bill. David, can you give us an overview of the bill, please? David, you're muted for some reason.
Sorry, that's my fault. Thank you. Good morning. Senate Bill 86 was requested for introduction by the Capers Board of Trustees during the Joint Committee on Pensions, Investments, and Benefits meeting on December 2nd, 2020. This bill would amend KSA 74-49-123, the section of the Capers Act that concerns the applicability of the Federal Internal Revenue Code to the retirement system. The bill specifically amends subsection C3 cap A, requiring a member to receive benefits at the later of April 1 of the calendar year following the calendar year in which the member reaches age 72 or 70 and a half. The member was born before July 1, 1949, or April 1 of the calendar year following the calendar year in which the member terminates their employment. The purpose of the amendment is to conform this section with the amendments made to section 401A9 of the Federal Internal Revenue Code that Congress made in the Federal CARES Act last spring. Under current law, the age is set at just 70 and a half. Again, this would actually change it to 72 or 70 and a half if the member is born before July 1 of 1949. The bill becomes effective in the statute book, and I can take any questions.
David, thank you. Committee, are there any questions? David, I see none. Thank you. Turn our attention to the proponents. We have Alan Conroy, Executive Director of Capers. Alan, welcome to the committee.
Good morning, Mr. Chairman. Thank you. And as always, David's done a good job explaining the bill. This is, as noted, this is the one piece of legislation that the Board of Trustees had requested introduction. And in the famous last words, it is a technical bill, but it does keep us, the gist of it is to keep us in compliance with the IRS tax code. Congress, as part of their response to the pandemic, over the last 14 months, they've passed two specific pieces of legislation that impact then ultimately then the Capers 457, which is the defined contribution plan. That's the voluntary employee, generally employee paid plan. And the one act was the that Federal Secure Act, and which was December of 2020. And then there's the CARES Act, which was passed in March of 2020. Both acts include provisions on the required minimum distribution from a retirement plans, which then gets you to that Capers 457 plan. As you remember, the Capers 457 plan, generally it's all employee money. The state participates in it, allows state employees to participate in it, and about a little over 300 of the 1,500 Capers employers also have adopted the Capers 457 plan as the optional deferred contribution plan. Our External Tax Compliance Council, ICE Miller, has advised us to keep our IRS tax compliance in line, that we have some guidepost legislation in Kansas statute that ties back then to that federal IRS legislation that all keeps us square for federal income tax purposes. And so our Tax Compliance Council, that ICE Miller firm, has recommended updating the 457 plan companion. There's a 401A, which is a separate part of that was affected by the Secure Act. That one, the IRS has permitted employers to make their statutory changes by 2024. However, I think the Board of Trustees thought if there was going to be a technical change for the CARES Act change, might as well go ahead and do both of these sort of technical compliance changes at the same time. And so the changes, though, again, relate to the minimum distribution levels established by the Secure Act, by that Federal CARES Act, and most of it relates back to the age for those required minimum distributions. Prior to the pandemic, it was 70 and a half. Now it's age 70, 72. And it would also maintain the age for required distribution at 7.5 for members that were born before July 1st, 1949, and that's, again, part of the federal legislation. So bottom line, there's two changes. One that probably needs to be done for sure this session, another technical change that could wait by the IRS provisions, federal provisions up until 2024. The board suggested doing both of these technical changes, keep us in compliance with the IRS tax code as related to our Capers 457 plan. So certainly be pleased to respond to any questions.
Alan, thank you very much. Committee, are there questions? Senator Pittman.
Thank you, Mr. Conroy. Appreciate that. I'm fully supportive of this. Just want to make sure for all our retirees that are looking at this, this has no negative no negative impact. This is an elective level where they might be forced currently to start taking minimum distributions at 70.5. This just merely pushes it to 72 when they are forced to actually take those distributions, right? So there's absolutely no impact on, they can still get those things if they want to. They're just not forced to, correct?
That is correct.
Thank you, sir.
Committee, additional questions of Mr. Conroy. Senator Pack.
Thank you, Mr. Chairman. We're making this change because of the, as you'd mentioned, the Federal CARES Act. I don't expect this to happen, but if the federal legislature should change something, I guess it really wouldn't impact this. We could still just stay with this.
Then I think at that point down the road, then we'd probably be back to you, because again, we try to keep the Kansas statutes in compliance with those IRS statutes, so there's no negative tax implications for the members. So if, I don't know, 3 or 4 years from now, Congress would change it back to 70.5, then to keep our compliance, we'd have to come back to the legislature for you to consider changing it back to 70.5.
But you said 3 or 4 years. It could be 1 year, correct? Historically, have we had to do this much at all? Or?
No, this is, I think, sort of a rare event. That 70.5 has been in place for a long time.
That's what I was thinking. Thank you, Mr. Chairman.
Yeah.
Additional questions or comments on Senate Bill 86? See none. Thank you, Alan. Committee, I will call your attention to a fiscal note provided that says that the Budget Office considers the changes in 86 technical and would have no fiscal effect. Are there any additional proponents on Senate Bill 86? Does anyone wish to testify as an opponent on Senate Bill 86? Any neutral testimony? Seeing none, we will close the hearing on Senate Bill 86. Okay, committee, it is my intention to work a couple of bills today. If you're comfortable with the bill we just heard, I think it's something that we could pass out today pretty easily. So, Senator Hildebrand.
Thank you, Mr. Chairman. Would that be an item that you would encourage us to send out on the consent calendar? Or do we have a better option for that bill?
Well, Senator Hildebrand, it is certainly a consent item bill, and I don't want to put anybody to a panic, but I'd rather not, because I think this might be a really good bill for my FI&I vice chair to carry as his first one.
Well, with that, Mr. Chairman, I will make a motion. We pass this Senate Bill out, number 48, favorably for passage.
We have a motion with Hildebrand, a second with Gossage to pass out Senate Bill 86. Any further discussion? Senator Peck. It's not part of the motion, but it is certainly my intention to allow him the opportunity. Senator Holscher.
Okay, I was raised in the FFA with parliamentary procedure. Do we not have to first request or move for emergency final action in committee and then pass it out? We don't? Okay.
Additional discussion on Senate Bill 86. Seeing none, all those in favor say aye. Opposed, no. Senate Bill 86 is on its way to the floor. Let's turn our attention to Senate Bill 78. Senate Bill 78, we heard earlier in the week, had a new number of provisions in it that updated some insurance regulations. Would anyone like an overview of Senate Bill 78 from Eileen? Good morning, Eileen. Why don't you just give us a quick 30-second overview?
Certainly, Mr. Chair. Good morning, committee. Senate Bill 78 was what we finally called the cleanup bill. It updated a variety of different statutes relating to the regulation of the business of insurance. So Section 1 was the contentious section that gave the commissioner new authority to make investigations and examinations pertaining and related to insurance fraud. It would have given the commissioner subpoena authority. Section 2 of the bill was pertaining to the definition of service contract and would strike the definition of the automobile services contract. Would strike the statement that service contract does not include an automobile club service. Section 3 was the section of the bill that defined the amounts pertaining to what must be met by a person in order to be considered an exempt commercial purchaser for purposes of surplus lines insurance. Instead of a calculation, the department would be able to publish an amount in rules and regulations. Section 4 of the bill was the section that changed the 1% to 15 basis points. It was a floor rather than a ceiling. Section 5, 6, and 7 pertain to the Utilization Review Organization Act. It struck the advisory committee. It struck the portion of statute that founded the committee. It struck the portion of statute that required the commissioner to utilize advice from the committee, and then replaced that advisory committee with URAC, the Utilization Review Advisory Committee. It's a national organization, and also stated that healthcare providers would be added to the type of utilization review activities that would require rules and regulations be adopted to establish the conduct of those activities, and also would state that URAC would be able to the reference to URAC would replace the reference to American Accreditation Healthcare Commissions in PSA 40-22 A04. Section 8 of the bill pertained to risk retention groups chartered in foreign states. This pertained to striking the requirement that the group's financial statement be certified by an independent public accountant. Section 9 of the bill pertained to registration of professional employer organizations, and it extended the time period from 60 days to 120 days after the registrant or the applicant's fiscal year within which the registrant or applicant needed to submit a fiscal report. And the bill also would repeal the Automobile Club Services Act, which is PSA 40-2501 through 40-2513. And with apologies, that was probably longer than 30 seconds.
Thank you, Eileen. Committee, are there any questions on Senate Bill 78? Okay, we do have a couple of amendments. What I would like is a motion on the bill, and then after that, we will begin working through the amendments. Senator Olson moves, Pittman seconds. Discussion, Senator Peck.
I guess I turned my mic off instead of turned it on. I do have a couple amendments. One of the first things that the department that Director Matos said when he stepped up to testify on Senate Bill 78 was the removal of Section 1. And so you will be receiving committee the balloon, which is just that. It just strikes all of Section 1. And when I first looked at this, I thought, well, Section 2 should be renumbered, and then I see in the reviser's notes that it says redesignate sections as needed. So even though you will see a Section 1 that will end up with no language, and then a Section 2, well, the sections will be renumbered. But again, this is just what the department requested, and I had visited with some in the industry, and they were certainly supportive of removing Section 1 at this time as they visit with the department to see if there can be some workable agreement. I'll be glad to answer any questions, Mr. Chairman.
Any questions on the amendment? Okay, seeing none. Motion the amendment.
Mr. Chairman, I would move that we amend Senate Bill 78 by this balloon by removing Section 1.
Second. Senator Gossage seconds. Any discussion? Seeing none, all those in favor of the amendment say aye.
Aye.
Opposed, no. Motion carries. Senator Peck.
Thank you, Mr. Chairman. There was also a request for some clarifying language as it relates, and you will receive from the committee assistant here momentarily a second balloon. This is on page 3 of the bill as it relates to service contracts and the automobile club service contracts and definitions and so forth. And again, this was requested that we place some clarifying language into the bill before we pass it out. So that's what I'm offering here.
Eileen, this is a little bit more language than what the was talked about in committee the other day. Could you give us a little brief explanation of why you had to write it this way?
I was on mute. So originally what the bill would have done would have just struck the service contract and stating that it did not include an automobile club service. Interestingly enough, this statute that says automobile club service as defined in KSA 40-2507, it was drafted in 1967 and does not define what a automobile club service is. So that statute was essentially no help. What I was going to do is just unstrike that and then add in the definition. So what we ended up doing was adding in the language that a service contract does not include an automobile club service contract, and then stating that an automobile club is any person who, in consideration of dues, assessments, or periodic payments of money, promises its members or subscribers to assist them, and you can read the rest of it. But because we have then person, thanks to Citizens United, which recognizes that person can mean not just a human being, but also an entity, we have to add person as a defined term. So person means any person, firm, partnership, corporation, or association that conducts an automobile club service business in this state. Lastly, because we refer to an automobile club service contract, in statute, we actually do not have that definition. So the best that I could do from our existing statutes right now is provide you what an automobile club service contract contains to give the reader or somebody who's looking at the statute the full picture of what all is being referred to as not a service contract when it refers to an automobile club service contract. It's kind of all the different pieces of the puzzle being put together. And then you would drop down to number 4, which would be unstruck or reactivated rather, to state that a service contract includes, but is not limited to, a contract that offers any one or more of the following services, and then you can just read down the bill as usual.
Eileen, committee, are there any questions on the amendment? The committee's pleasure on the amendment.
Thank you, Mr. Chairman. I would move that we adopt the amendment that I presented.
Second. Senator Gossage seconds. Any discussion? You may.
Mr. Chair, just to be clear, this is saying that if I have an automobile club, as you've defined it, just like we were talking about before, and I don't do insurance, therefore I'm not subject to insurance laws, right? But if I do, if I'm a AAA and I have insurance, I still am subject to insurance laws, correct? Is that right?
Eileen, did you hear the question?
Yes, that's correct, Senator
Thank you.
Pittman.
Any further discussion? Okay, seeing none, voting on the amendment, all those in favor say aye. Aye. Opposed, no. Motion carries. The bill is adopted. Any further amendments on the bill? Okay, is there a motion on the bill as amended? Senator Olson? Second? Senator Pittman seconds. Any further discussion? Seeing none, all those in favor say aye.
Aye.
Opposed, no. Motion carries. Senate Bill 78 as amended is headed to the floor. Okay, committee, that is all we have for today. We will have a pretty full week next week. We will, on Tuesday, hear Senate Bill 135, which is a KPNF bill. And then on Wednesday, we will hear an OSBC trust bill and an OSBC mortgage bill. And then on the 17th, we will hear a bill concerning securitization and bonding. It'll be a pretty full week. With that, we are adjourned.